will be more.
Really?
Let's say, yeah. The problem is that we have 3 workshops going on at the same time, so they're.
The other
split.
workshop is huge. Like the one I walked by,
Did
it's
you?
way more intimidating than this room.
What was the topic? Because we have diversity and inclusion, and the other is in-house practices. So Eric, who you want to
Tell me whoever.
¿Le paso el micrófono?
Right.
No, completely talk about it.
Well, is he actually going to say a biography of us?
No, he said that the video doesn't include a bio,
Oh.
but I mean, let's see.
Yeah.
Maybe he doesn't know and it does include something. So if the video has something on our bios, we might just say
Yeah.
hello and nothing. I mean, I don't know.
Hola, buenos días.
Hello, good morning. We are starting this workshop of cannabis and intellectual property, a global view. Thank you for being here. And we will have an introduction video, and then we will talk with the panel chairman that will be in charge. Thank you.
Propiedad intelectual. Una
Cannabis and intellectual property, a view, a global view. Eric Moran, McDonnell, Boehnen, Hoffman, United States. Natalie, Rizkalla-Kamel, Gowling, WLG, Canada. Gloria, Niembro, partner of Chevez, Ruiz, Zamarripa, Mexico. Chairman, Shabnam, Malek, partner of Brandon Branch, United States.
Everybody, thank you for coming to the Cannabis and Intellectual Property panel that I will figure out the slides in a moment. Oh, yes, please, thank you. I'm Shabnam Malek. I'm actually have moved from being in private practice, and I now am the general counsel of a cannabis company in the United States based out of Colorado. We have our panelists here from a few different jurisdictions, and we are going to spend some of our time in the beginning talking a little bit about some history and the legal status of cannabis in various jurisdictions to give a groundwork for the intellectual property conversation in the second half of the program. We will be covering these topics, so we'll do an overview of the cannabis sector. We're going to discuss a case study with a fact pattern, and we'll ask some questions of the audience toward the end of the program. We will discuss branding restrictions, trademarks, a little bit about advertising. We'll cover the United States, Mexico, Canada, and perhaps some other jurisdictions, a little bit on Europe. We will touch on cannabis-related patents, largely focusing on the United States. And then we'll circle back to the rest of the case study and walk through an example of a cannabis company based out of the United States and experiencing some growth. So of course, this is just general information, and we're not providing legal advice, but you can always reach out to any of us for questions. Great, so let's start with the cannabis sector in the United States. This is the company that I work for. So I'll give you a quick history of the United States. As many people may know, actually, a long time ago, cannabis was used legally as a medicine in the United States. And over the period of the early 1900s, a movement arose to really make cannabis illegal and make it morally corrupt, and it was often thought to be associated with xenophobia and racism, and it ultimately led to the illegal status of cannabis when Nixon placed cannabis on the Controlled Substances Act, Schedule 1. And it was actually, the law was new at that time. And it placed cannabis along with some very serious drugs on Schedule 1 of the Controlled Substances Act, And what that means in the United States is that the items, the drugs on Schedule 1 have no possibility for medicine, no purpose for research, that they are highly prohibited. There's no version that is acceptable. There's other schedules, there's Schedule 2, and substances like cocaine, for example, are on Schedule 2 because there is actually a medical use. And then it goes farther down and gets more liberal, and ultimately there's obviously products that are not on the schedule at all. So what happened is the cannabis was on the Controlled Substances Act, and it still is. Cannabis is still illegal at a federal level in the United States. In 1996, California was the first state to essentially permit a medical program for the use of cannabis and the cultivation of cannabis. And over the past 30 or so years, we started to see a movement at a state level where the states legalized cannabis in some form. So in 1996, we legalized medical cannabis, and I say legalized in quotes because really we provided a defense in our criminal code. And over the next decade, about another 10 states legalized. And then in 2012 is when we had 2 states develop formal programs for legal, regulated adult use cannabis. So that means essentially like alcohol. Anyone 21 and older could purchase cannabis, starting in Washington and Colorado. That's actually when I started to turn my focus around that time to the cannabis sector as a lawyer. And then it took about really maybe 2 or 3 years for these states to implement their legal regulated system. From there, we continued to legalize. We actually, in the past election, earlier, I guess it's December, in last month's election, we had another state legalized, that's Ohio, and that means Ohio will soon have a system where anyone 21 and over can purchase cannabis. When we talk about adult use markets, I'm always talking about 21 and over. States that have medical cannabis, generally, that means 18 and over. So this is just an example of what legal cannabis looks like in the United States. The states that have no color, we call them prohibition states, and that means maybe there is a form of like CBD or very low THC product, but all the other states have legal cannabis systems. Any state that has legalized in the United States also has some sort of regulations that govern the commercial sale, cultivation, and retail of cannabis. This is now outdated because I made this slide before the election. So we have even more states that have a legal adult use market. A lot of Americans have access to legal cannabis, and we estimate that 69 million Americans will consume cannabis by 2030. And that has impact, as we'll talk later, about some of the trademark laws in the United States, thinking about these consumers who have access to legal cannabis. So it's a big market in the United States. Annual legal sales in 2022 hit $30 billion, and this is the adult use cannabis market. This isn't hemp. Projected sales is going up to $35 billion. What's really interesting to me, actually, is that in many of the states, the cannabis companies are experiencing a lot of difficulty financially because these dollars don't always translate to revenues for cannabis companies for various reasons. One is difficulty with licensing, difficulty with an illicit market, and a really high tax regime. So we have a lot of states that have different forms of legal cannabis, and California tends to be the highest sales of any of the states. You know, it's the biggest market. We have the most number of people. We also have a very big legacy market because California has had, like you saw before, some form of legal medical cannabis for a really long time. I'm a California lawyer, so it's all focused on California. And in terms of the product types, and I'll show you some examples of product types and packaging later, and it'll actually come up in our distinction in jurisdictions. But in the United States, in most of the jurisdictions, flower, meaning the actual cannabis plant, tends to be the highest sales of any of the products, the greatest market share. After that are the vaporizer pens, so that is the cannabis turned into an oil through various different methods, and then usually put in like a little pen that you just inhale. Everybody sees it with tobacco these days. And then we have edibles and beverages. The company that I work for makes a pressed tablet, a pill that has cannabis in it. There's a lot of new formats coming online, and edibles and beverages are actually a popular growing sector of the market, particularly with older consumers. So how do we have legal cannabis markets when we have an illegal federal system? Well, the solution mostly is that two presidents ago, we had the Department of Justice issued a memorandum that said the federal government would not enforce against any commercial cannabis sales in any state so long as that behavior was compliant with that state's laws and regulations. And that's basically the only thing that's keeping the United States separate markets legal. Before we had what is now called the Cole Memo, we actually had lots of enforcement. In California, we routinely had raids of cannabis dispensaries. People were arrested, even up until after Colorado had legalized and Washington had legalized, because California had not legalized and did not have a regulatory market. So it was really helpful we had the Cole Memo. The Cole Memo is actually now more or less suspended, but we still operate under the same framework. And we also have some legislature that's passed that prevents the spending of money on enforcement in situations where companies are compliant with state laws and regulations. So what makes the states different from one another? This multi-state system we have, it's really complicated, and the laws of every state are different from one another. Even the way cannabis became legal is often different, sometimes by voter initiative, sometimes the legislature acted, sometimes there was a constitutional amendment to a state's constitution. So everything can be different from state to state. That means the regulatory systems, some states may have a licensing framework that requires one company to hold all of the licenses. That's vertical integration. Some states prohibit that. Some states prohibit certain product types. And I'll get to this later, but for example, in the state of Nevada, you cannot have a hard candy with a stick in it. You have to have a hard candy without a stick in it, like a lozenge. Each state has a universal symbol. That means, and I will show you examples later, a symbol on the product packaging, and these symbols are different from state to state. And in some states, that universal symbol must go on the actual product. So a chocolate bar will have the universal symbol on every serving of that chocolate. That's true of the state of Colorado. We have warning languages that are required to go on product packaging that are different from state to state. And I'll show you some examples, and I'll tell you this is what makes being a cannabis company in the United States so difficult, because you can imagine it's hard to order product packaging and use it in all of the states where you operate, because the packaging itself may be different from state to state. So here are some examples of regulatory differences. Florida requires vertical integration, and you must have a lot of money to enter that market. It's a medical market. So that means you have to be able to afford to do cultivation, manufacturing, and retail sales with the same company and the same series of licenses, and they only have 22 licensed operators for the whole state. In Washington, it's actually prohibited to hold multiple licenses in the supply chain. In California, it's unlimited licenses. You can have any kind of license you want and more than one, except you may not have a license to test cannabis if you have a license to do something else in the commercial market. We also have a lot of local control. So any city or county in California may set its own rules. It may prohibit commercial cannabis. It may have a taxing regime that's different than another county or city. Some other differences. In Connecticut, you may not have any pills in the adult use market. So if you're a company like my company and you want to enter Connecticut, and the only product you have is pressed pills, it's not a good decision to move into that state. In Nevada, no lollipops. I had a client that was a Colorado-based company that the entire product line was lollipops, suckers, and they moved into Nevada, and they had to remove the stick and turn it into a lozenge. In New York, you cannot have home grow. That means you cannot grow cannabis for yourself at home. This is true of Washington. This is very controversial because people generally think that the ability to grow cannabis at home is important for medical cannabis patients. So here's the warning symbols. This is just 3 different ones. So if you're a cannabis company in California, that must go on your product packaging. And if you're a cannabis company in Colorado, that must go on your product packaging and on the actual product. And then New York has this complicated, giant thing for adult use. Some examples of warning languages, and I'm going to go through these fast, but I think you have, or we'll get the slides. So this is, all of this language must appear on the product packaging and on advertising. I was just telling Eric earlier that in New York, the number for poison control must go on the advertising for cannabis products, even though, like, obviously it's just the advertising, it's not the package. This is the California product warning label, and this is with all the other things that go on the label. So you can imagine it's difficult for branding to squeeze all this on there, and it must look exactly like this, all capital letters, the whole bit. Can you believe this? Just for cannabis. Okay, Illinois, for infused products. My goodness, it's a whole paragraph. Okay, and so the important thing to remember about the US market is that even though we have multiple states, many states that are legal, we have no interstate commerce. So even if you have 2 states next to each other, Washington, Oregon, and California, and Nevada, and all of them have an adult use system, you still may not engage in commercial transactions that cross state lines. So what this means for cannabis companies is that you have to have either licenses and operations in each state that you wish to operate in, or perhaps you do something like the company that I work for does, and that is intellectual property licensing to somebody who does hold a permission to operate in various states. There are some folks actually that are working on like interstate treaties so that they can create some interstate commerce and markets across states. But it would be difficult even if we do get that, because obviously all the other stuff that I said about differences in labeling and packaging, we have different advertising rules. And there's also no international export or import in or out of the United States. So when you're traveling to the US and you purchase some cannabis products in California, don't bring them home with you. It's not lawful on either version, actually. It's not for Mexico and not for the US. And you cannot ship into the US. We also have really complicated rules for banking, which impacts all the global cannabis markets. Anything that touches the US banking system is going to have problems because the US banks generally don't bank for cannabis companies. Okay, I'm already taking up quite a bit of time. I'll move fast. So let's just look at some products. This is what cannabis products in the United States look like. This is product packaging. You'll see some of these have the appropriate labels on them and the symbol. This is flower, so this is what I was referring to is about 40% of the market in most states. We also have a lot of pre-rolls. In some states, these are considered manufactured products. In some states, a cultivator can make a pre-roll. We have some really beautiful packaging. It's a very sophisticated market, actually, in the US. Okay, we have edibles and drinks. That company on the far right actually is already out of business. It was a California company, could not survive licensing. Incredibles is a Colorado company that was actually acquired by GTI for several $1 million, lots of acquisitions, lots of money going into and out of these cannabis companies. And these terabytes are by a really famous California company that actually created some kind of bad case law in the world of trademarks that we'll get to later. Let me say one thing about that hi-fi hops. So in most states, you're not allowed to mix alcohol with cannabis. So there isn't cannabis-infused beer or cannabis-infused wine. So this company, Lagunitas, it's a California beer brand. They created a hop water without alcohol in it, but infused with cannabis. In most states, it's prohibited to have alcohol and cannabis together. And in most states, it's also prohibited to have tobacco and cannabis together. Okay, so topical tinctures and more. you'll see there's everything, all types of products with cannabis in them. And vapes and extracts. So this is the second biggest share of the market. There's everything from like shatter, you can just buy the actual extract itself, or you can buy it in a vape pen. These are going to be part of our case study and actually prevent lots of opportunities for brand development and brand protection. So there's also a big non-plant touching sector. I think one of the mistakes people often make is they think if they are offering some sort of service for the cannabis sector that maybe it is fully legal, but in terms of banking and money laundering laws, often the federal government does not distinguish between whether or not you are actually touching the plant in your commercial transaction or not. Any money you're making from the cannabis sector is still subject to some of the banking rules and could become a money laundering issue. And this is what the branding looks like. It's very sophisticated, very beautiful, and many of these brands are registered at the United States Patent and Trademark Office, and I'll talk about how later. So interesting things going on in our cannabis sector that I don't actually think is true of many other cannabis sectors is a lot of celebrity collaborations. In fact, my guess is it's specifically prohibited in Canada. We'll talk about that later. We have an appellations project developing right now in the state of California where people want to associate cannabis with a particular region and a cultivar. It's fascinating, and some of the restrictions at the U.S. Patent and Trademark Office are pretty much the thing that's getting in the way. We are seeing maybe a development of an interstate commerce system, like I was saying earlier, through state pacts. It requires the governors of states to work cooperatively together. And finally, we have a hemp cannabinoid market that's growing that we'll maybe touch on a little bit later, but this is a federally lawful product that still has cannabis in it, and I'll talk briefly about that as we move forward. This is just an example of some celebrity collaborations. We have pretty loose advertising in the United States, but not completely loose, not completely allowed. And again, every state has its own advertising rules. So it's kind of a problem. Okay, great. So we're going to hand it over to Natalie to go over the Canadian cannabis.
Good morning, everybody. I'll just tell you briefly a little bit about myself and my involvement in the cannabis sector. I'm a trademark lawyer at Gowling WLG in Toronto. I've been at Gowling's for 16 years. Cannabis was not something I practiced 16 years ago. I started to become interested in the cannabis sector when it was going to become legalized in Canada. So Canada is federally legalized, and it became federally legalized in 2018. So by 2016, 2017, I actually had a really good friend that was getting into the cannabis sector and came to me with all these questions regarding cannabis and branding. And so that was my into the cannabis sector, and haven't looked back since. So the story of cannabis in Canada is very different than in the United States, in the sense that just generally it's legal federally, but there's not much you can do with brands. So I'm going to tell you a little bit about that. And I'm looking at Shabnam's, all of her slides with all these sophisticated companies with beautiful branding, and then you'll come to Canada and you'll see how different it really is in Canada. But let me just start. I don't want to go too much into the history, but this started back in 1999, where there was legal access to dry cannabis for medical purposes. That started there, and then you go through a series of different regulations related to medical use, and then in 2018 is when our Cannabis Act and cannabis regulations were enforced, which controls and regulates the production, distribution, promotion, and sale of cannabis. And then 1 year later, exactly, we had some amendments to allow for the production, distribution, and sale of edibles, topicals, and concentrates. So that's where we are now. So that's 2019, we're in 2023. So I'll tell you a little bit about what's been happening. So again, just October 17th was when we got the Federal Cannabis Act and regulations. And what it did is it decriminalized cannabis and provided legal access to cannabis for recreational, industrial, and medical purposes. It's federally regulated, but then the provinces, and I'll talk about later, do regulate consumption and retail of cannabis. And then our regulations provide the guidelines for obtaining federal licenses for cultivation, processing, research, analytical testing, drug, and sale. It also provides the very detailed restrictions related to plain packaging and promotional restrictions. We do have one standardized cannabis symbol that's used on our branding, which you'll see on the slide there. Within the Cannabis Act, what is the definition of cannabis and what is not cannabis? So cannabis is a part of a cannabis plant, including, it's part of the cannabis plant that's, and regardless of whether that has been processed or not, it include any substance or mixture of substances that contains or has it on any part of such a plant. And I don't want to go through this definition in detail, but what is not cannabis is a non-viable seed of a cannabis plant, a mature stalk, without any leaf, flower, seed, or branch of such a plant. So in Canada, you need federal licenses to do all of these things, which is cultivation, processing, sale of for medical purposes, for research, for analytical testing. And then, as I said, the provinces have their own laws to address consumption and retail sales. So when you come to Canada, you can buy cannabis, but it depends on which province you go to where you can buy the cannabis. So in some provinces, it's just done similar to alcohol, where it's by the government. Some is through private retailers, and then, for example, where I'm from in Ontario, there's both. You can buy it from the government, or you can buy it from retail outlets. There's also promotional restrictions for retailers as well. Yeah, franchises are allowed, yeah. So just about 2 or 3 weeks ago, there was a report released. It was called the 2023 Legislative Review of the Cannabis Act. And it was an expert panel that was brought together. I think there was like 500 stakeholders that were involved in this and 90 meetings. And it's phase 1 of re-looking at the Cannabis Act and seeing what changes can be made. And so this report was just a report of how's it going. And then there'll be further phases where they provide recommendations to the government of what needs to change. But just to give you an idea, between 2018 and 2021, the cannabis sector in Canada created 98,000 jobs and added 43.5 billion Canadian dollars to our GDP. Almost $8 billion was spent on cannabis in Canada in 2022. With 5.1 billion of that being in the legal market. There's still 2.4 billion in the illicit market. And then as of March 31st, 2023, there was 913 license holders authorized for cannabis activities, including cultivation or processing. Just to give you an idea of the method of consumption of cannabis in Canada, of the Canadians that do use cannabis, 70% of them smoke cannabis, and 52% consume edible cannabis, and then some other stats there. But the two highest are smoking and consuming. And then in terms of export and import, it's very, very limited, prohibited without a license and permits from Health Canada. License and permits may be issued only for medical or scientific purposes or in respect of industrial hemp. A permit is required for each shipment. And Health Canada's general policy is to issue permits only in very limited circumstances, such as importing starting materials, exporting cannabis to another country that has a legal regime for access to cannabis for medical purposes, or importing or exporting small quantities of cannabis for scientific purposes. So this was I'm not going to go into detail on everything that came out of this expert report, but I do have a few slides here of what they found related to what's interesting to IP lawyers, which is basically there were a lot of stakeholders that wanted to see different, more streamlining of the advertising and marketing and promotional restrictions. A lot of stakeholders found them to be too restrictive. In terms of the industry general sentiment, what came out of this report is it's a hyper-competitive cannabis market for producers and retailers, combined with the various regulatory fees, distributor markups and fees, and taxes are stifling companies of all sizes. So that's where we are today. When I started in 2018, there was so much work. Everybody wanted to get into the cannabis industry. And this is what's happening now, where there's been a lot of acquisitions of the smaller companies, and it's a lot of bigger companies now, almost similar to the pharma space, where it's the big companies that have taken over in the cannabis space in Canada. In terms of the impact of laws and regulations on competition and innovation, again, this is related to our regulatory restrictions. It came out that there's an inability to differentiate from other companies due to stringent promotion, packaging, and labeling restrictions. And then Health Canada's guidance is not always clear, and Health Canada inspectors are not always consistent in their observations, reports, and application of the rules. So this is also a problem that I came across where I'll have a client that will want to do all these kinds of things with their branding and their promotion. And they say, well, the other guys can do it. The bigger guys are doing it. Why can't I do it? And it's because Health Canada isn't consistently enforcing yet. It does take one or two examples, I guess, to stop the others. But because it's so new, they haven't really enforced to the degree that you would want to see in order for there to be consistency. And also in terms of inability to differentiate from other companies. If you walk into a cannabis store in Canada, you don't really know what you're buying. Everything looks the same. And I'll show you an example in the next couple of slides. But there's what you can do with trademarks is limited. And I'll pass it over to Gloria.
Thank you, Natalie, Shabnam. My name is Gloria Niembro. I am a partner at Chevez, Ruiz, Zamarripa. I am very happy to be here and welcome you all, being that I am Mexican. So I hope not to disappoint you in the sense that I have fewer slides. I have nothing related to branding, maybe a couple of images at the end when we go through the trademark slides. But I think it's important for you to understand a little bit of one example of Latin American landscape in terms of early stages because of all of the downsides or the stops that we have been receiving from the executive power here, the Mexican government. And just as a very quick intro, Mexico opened up to medicinal cannabis a few years ago, as opposed to the US system where it has a lot of states can legislate on the matter. In Mexico, it has to be federal, similar to Canada. It is important to understand that Mexican landscape is really tricky. It can be complex, and that also can trigger or scare away the high investments in the country. So I'm going to talk a little bit about the lack of political will when it comes to advancements of different uses of the cannabis and products and derivatives. And the importance also of exploring the limits of the regulatory landscape in Mexico so we can assess risks and opportunities. And actually, we have seen that with the strategic litigation, you will have openings in the market if you understand the legal landscape, so we can have a little bit of certainty. So this first slide. I would say that, well, it all began in 2009 when the legalization of drug possession, always in connection with the small amounts for personal consumption. After that, 2017, the medical use was approved, and an important amendment was done to the general health law. And we have there a little bit of detail about that. The use of medical marijuana with a THC content of less than 1%. After that, 1 year later, the recreational use was somehow allowed, but not in a law. It was with a declaration of the Supreme Court. This was a big groundbreaking decision, I would say, from the Mexican Supreme Court, where it proved that the judiciary was driven by the civil society and not by the Mexican Congress. And actually, sadly though, this declaratory came into effect until 2021. So imagine that, 3 years later. So, but this was a very nice and promising advancement, because the absolute prohibition for the recreational use of cannabis was eliminated, okay? So in 2020, what happens about the regulation of the medicinal cannabis? We finally have regulations that are trying to put more detail into how we're gonna implement this medical use of cannabis and derivatives. And also a big regulation about investigation for scientific purposes was implemented. And here, it's just important to notice that there was some guidelines issued for cultivation, production, and distribution for medical purposes. After that, in 2021, the industrial use was allowed via an amparo, which is a constitutional action. It has no general effects, and this was granted to a Canadian company based in Mexico, well, a subsidiary in Mexico, Zebra Brands. And they actually received an important permit this year, 2023, that was derived from the Supreme Court decision that allowed the cultivation, processing, production, and commercialization of industrial cannabis. So a lot of opportunities for all the infused cannabis goods. And then, which is in line also with, this decision is in line with the driven power that has been going on with the Supreme Court rather than with the Congress regarding the recreational use as well. I am confused with the laptop and the big screen. Thank you. So there has been a lot of efforts to have a Cannabis Control Act. This was a major one that unfortunately is completely frozen at the Congress. But let me tell you just a little bit about this history. 2021, the Congress actually, they implemented a bill for the federal law for the regulation of cannabis. And it was approved with some changes, and then the Chamber of Representatives made additional changes and came back to the Senate. And long story short, it didn't pass through. It is not current law at the moment. And this shows how, despite of all the judiciary efforts and persistence so that the Congress could legislate on the matter, they have been really reluctant to it because of the definite no of the executive power. So we are hoping that maybe in a couple of years we will see a difference. Let's hope for that. So just to summarize, these are the uses that are permitted under current law and considering the precedents that we have gone through. Here for the medical use, I just want to mention that there was an important case in 2015 about the first authorization to import medical cannabis via a judicial process. Again, the Congress was doing nothing at the moment, so there has to be a legal process has to be initiated, and it was to treat a specific syndrome for a child. And then after that, we had a lot of isolated cases just to be able to import cannabis or cannabis-related products for medical purposes. And after that, we already said that 2017 and 2021, 2020, we had the law and the specific regulations for this medical purpose. Investigation is related to medical purposes because it was allowed for the investigation in the field of medical advancement and for scientific and therapeutic purposes. And when it comes to the recreational, we already said something related to it. Just to mention that possession actually, currently, from a reading of the law, possession is allowed of 5 grams only, which is very little. So we had an important case, we're gonna go through it in a couple of slides, that was declared unconstitutional because it was way too low. And finally, well, industrial, there was this case of success by the Zebra, the Canadian company. They got this permit in 2023, and with this, just to advance, to anticipate something, from the trademarks perspective, they were able to secure registrations for pharmaceuticals, beer, teas, and other cosmetics which are related to the infused cannabis industry. So this is, I mean, if you are willing to invest and to spend time with strategic litigation, you will be able to do something big. This company, they will be the first with this kind of permit in Mexico. So, and there's no actual limitation to the commercialization they can do right now for industrial purposes, which is huge. They hit first, they will hit in a very big scale. This is only a brief slide. I'm sorry.
No, that's okay. We can do that.
Right. Again, a confusion. On constitutionality action in 2018, that was published in June 2021. That was the first time that the Mexican Supreme Court, with general effects, this means this is mandatory to everyone, that it was the prohibition of cannabis for recreational consumption was deemed against the right to free develop of the personality of an individual. So one of the consequences of that was the use of marijuana was allowed for recreational purposes as long as it was for personal consumption, right? Because we're not talking about industrial uses here, but recreational, which is very, very different. And finally, just a very short slide about the power that this authority has in Mexico. This is the Federal Health Department, and they are in charge of protecting any sanitary risk derived from a lot of products, including cannabis and other drug-related goods. So this is just a little bit of history about what happened in Mexico, what is going on. And let's just assume for 1 second that cannabis was entirely legalized in Mexico. What would that mean in Mexico? There's a lot of speculation about, and actually one of the bills include this, of creating a specific institute in Mexico to regulate all the cannabis from farm production to exportation. So this current Cannabis Control Act includes that that creation of this institute, which will include everything from cultivation until export and import. Once again, a disclaimer, this is not conclusive. As we said, this is in discussion in the Mexican Congress, but if we are talking about full legalization, the government has said that COFEPRIS would not be the only authority involved in the cannabis industry in Mexico. I think that would be it. And we're going to be talking about an example regarding vapes. I just want to show you that in Mexico we have no specific regulation for THC vapes. The government, once again, the federal government, issued a couple of decrees that prohibited the commercialization of these e-cigarettes. And this ban includes also the solutions that are used in connection with the devices. But again, our hero, the Supreme Court, in 2021, they declared the first decree unconstitutional. So you still have to litigate that with the judiciary, but you can have a decision that will favor your interest. And then go back to the regulatory authority to get all the permits in order to be able to commercialize. and I'm going to hand you over for the marketing.
Yeah, I'll take it back over for a second. I think, and actually we have another microphone right there. I wanted to back up a little bit. A few things that both Natalie and Gloria said kind of made me think. I want to talk about the plant for one moment. So when I say that cannabis is illegal in the United States, our definition actually of cannabis is very specific, and it was interesting seeing your definition, and I think I have shortened my slides maybe too much. What is considered illegal cannabis in the United States is marijuana that has a THC concentration of greater than 0.3%. And THC is the cannabinoid in the cannabis plant that people think of when they think of the effect, the impairing effect, or getting high feeling of cannabis. We actually have two versions of cannabis that are legal in the United States. One is industrial hemp, and that is carved out in the Controlled Substances Act, and it's the mature seeds and stalks of the hemp plant. And when I use the term industrial, I mean more hemp and industrial uses of hemp rather than your meaning, which sounds more like manufactured cannabis products. And then in 2018, our Congress passed the Agricultural Improvement Act, people call it the Farm Bill, and it legalized any form of cannabis that has no more than 0.3% of THC. As a result of that bill, we've actually had a really big industry arise around cannabis products that come from the hemp plant. And so this is a little debatable, what I'm saying, or controversial, but the source matters in the United States. So if the source was a plant that had more than 0.3% THC, it's federally illegal, and that's the state-regulated system. If it has less than 0.3% of THC, then that's federally legal, and it's generally considered hemp, or, like I had said in one of the slides, hemp cannabinoid. So it's like this two system, but it's the same exact plant. The only difference is this THC level. Let me see where we are in the slides. Not totally sure. Oh, great, okay, branding and marketing cannabis in the United States. Here I am again. So it's interesting what Natalie was saying about how plain packaging has created an environment in Canada where you can't distinguish between the different products. And also, if anyone has any questions, feel free to raise your hand. We have, Gloria will translate for us. So we have actually a similar challenge in the United States, and it's not that you can't distinguish between brands because we don't have plain packaging laws, or we have restrictions on packaging and branding, but not to the extent that Canada has. But our problem in the United States is actually the lawful use doctrine. And I'll talk a lot about the impact because I think from a trademark perspective, this is the primary challenge that we face in the cannabis sector and the obstacles that it gives rise to. So we'll talk about lawful use doctrine, but some of the other challenges that we face as trademark attorneys in the cannabis sector are clearance searching, which is very difficult, and I'll touch on that a little bit. We'll dig into obstacles to registration. Enforcement is very difficult, brand enforcement in the United States, and I actually will talk about some cases there. And because of this enforcement problem and the lawful use doctrine, which we'll dig into, we have similar competing brands in the United States that are able to exist in different states because we don't have a federal framework for cannabis. And we have differing regulatory schemes, which I was talking about earlier, which really does impact branding and brand development and brand goodwill. Okay, so cannabis federal trademark rights. So we do not have a lawful federal system or federal laws for cannabis, and as a result, we do not have federal rights in trademarks arising out of use of the mark in connection with cannabis goods and services. And I think this is the most important distinction between the United States and pretty much every other jurisdiction in the world, but importantly here, Mexico and Canada. So cannabis companies in the United States that are participating in this $30 billion market and have those fancy brands and packaging, they can't get trademark registrations at the U.S. Patent and Trademark Office for the cannabis goods. So if they say, you know, I'm selling pre-roll, a joint called Juju joints, and in the goods and services identification, they say cannabis cigarettes or cigarettes with cannabis flower in them, they will get refused registration because the goods are unlawful. And this is an important distinction between the US and other countries. The mark itself is fine. There's no, and actually we've had a lot of case development on the issue of immorality and things of that nature. We don't have that problem. Your trademark isn't being refused registration because it says cannabis or because people think cannabis is immoral, which they do think that. The reason the trademark registrations are being refused is because the goods and services are illegal. Now, what I was saying about the Farm Bill earlier, that Farm Bill has created a situation where you could get a trademark registration for use in connection with hemp flower, so long as you say in your identification that the hemp flower has no more than 0.3% THC in it. Despite that, and setting aside this sort of carve out for hemp goods and services, a lot of cannabis companies have developed really big trademark portfolios. I've done this myself. And the way that we go about it is we build out like a blanket of coverage using the lawful goods and services that the cannabis companies offer. Oftentimes, it's consulting services, it's information about cannabis. And some of the ancillary companies have strong brands solely providing information and reviews about cannabis. Or there's a lot of companies will help identify where cannabis dispensaries are located. But a plant-touching company, by and large, is going to have a trademark portfolio that consists of lawful goods and services that don't include the actual cannabis products. It's a complicated system, and it's complicated for global portfolios. So here's some examples. You know, we don't really always do all of these things, but if you've got a cannabis company that has really unique packaging, it's nearly impossible to get a trade dress type registration, but you can register the sale of the package itself, like the manufacturing of packaging and things of that nature. Bar or cocktail lounges, some states allow for cannabis consumption. California does, Colorado is starting to. So you could obtain a registration for a bar or cocktail service, but if you get an inquiry from the examining attorney about what is offered at this bar or consumption lounge and you say the consumption of cannabis, they will refuse registration. So it's really tricky. Oh, and there's in the orange box. Applications for goods relating to cannabis or CBD derived from hemp could be granted. The important part there is actually the second half of the sentence. If the goods or services comply with other federal laws. So despite the fact that we have lawful hemp in the United States, we do not have a lawful sector for edible products that include hemp derivatives. So if you're making a hemp-infused or a hemp cannabinoid-infused beverage, you still can't get a trademark registration if those are your goods. And then the company CoreSearch actually has done some really interesting gathering of data I thought I would just briefly share, showing the numbers of cannabis-based applications and then registrations. The light green line is applications filed between 2000 to 2023 on the top box, and the dark green lines are the registrations. And they actually compiled this globally to show what's been going on around the world. And you can see Canada, lots of trademark applications.
I was just going to say, Canada, there's lots of trademark applications, but there's such a backlog, like
Right.
for examination. So that's why you'll see a lot less registrations, because if it's between 2023, right now the Trademarks Office is examining applications from 2019.
Wow. I have some clients that I've disengaged that still have applications pending in Canada.
Yeah, but the good story is, and actually related to cannabis, is that you can expedite your applications in Canada if you amend your application to be goods that are on the goods and services manual. And there's many goods and services. All the cannabis goods and services are covered. So you can go back and amend it as long as you're not broadening and expedite it so you can see the dark green increase.
Yeah,
You'll get
in
more
the-
registrations because they'll be expedited significantly.
Right. That's actually really interesting. So our ID manual obviously does not include cannabis goods and services in it. And then they also compiled this data for hemp. And it's interesting to see in the EU how many registrations there are for hemp goods and services, and in the UK as well. And the US is really growing. Just an interesting global perspective. So the question we get the most often, I'd say, as trademark attorneys in the United States is whether or not a strain name or a varietal name can be protected at the US Patent and Trademark Office. And the answer is generally no. And it's a big part of the cannabis sector branding attempt, I would say, is using cultivar names as brands. What's interesting is you can actually apply to register a plant patent in the United States, and you could associate your cultivar name in that application. But if you apply at the USPTO and you use a cultivar name, the examining attorney will conduct research and figure out that that is essentially what we say a strain name and will refuse registration. This includes even if your goods and services aren't describing the cannabis plant. So if your goods and services are providing a website featuring information about cannabis and your trademark is a cultivar name, you might get a refusal or an inquiry about whether the information is about that varietal of cannabis. It's a really broad restriction and prevents a lot of trademark registrations. So here's our case law that is developed. So the lawful use doctrine has been around for a really long time in the United States. It's not statutory. It's developed through more historic case law and has kind of like been revived, I would say, in a lot of ways for the cannabis sector, especially for us. They decided to start refusing these applications. And we have a series of cases that have really made clear that if your goods and services violate the Controlled Substances Act or another federal regulation like the Food, Drug, Cosmetic Act, then your trademark application will be refused. This is true even if you apply on an intent to use basis. That means in the US, you can apply on intent to use, but you only may get your registration once you demonstrate use. But even if you are not expressing use at the time of filing, you will still get refused registration if the goods or services are in violation of federal law. What's important here is that this is true for non-US based applicants and registrations coming into the US. So you may never have had to show use, or your goods and services may be legal in your country. When that application comes into the US based on 44D or 44E, in our trademark laws, the examining attorney will still refuse registration even if you don't need to show use to obtain that registration in the United States. It's a big impact on global portfolios, Paris filings, Madrid filings, the whole thing. So our case law, so it started at the US Patent and Trademark Office with the registrations that were refused and appealed, and then the Trademark Trial and Appeal Board said very clearly, no registrations. And then we saw the same thing develop in the district courts and the federal courts in the United States. In this case, the Kiva Health brands, what's most important about that case is that the court actually recognized that the California cannabis company called Kiva had rights that predated the other side's use of the mark. The court acknowledged that, and there was a chain of title to establish that, and it still refused to grant Kiva any rights at a federal level because the use of the mark had always been in connection with federally unlawful goods and services. Even if you show up at the court with state lawful goods and services, the federal courts are still going to deny you relief. Okay, and then in this case, actually, we had a hemp company and a Colorado cannabis company have a dispute over the identical mark Veritas. And in this case, the court said that there wasn't even use of a trademark, that the nature of the use of the trademark in connection with informational services on a website didn't even amount to use. And so the hemp company was the only user of a trademark in connection with lawful goods and services. And then we have this most recent case coming out of the Ninth Circuit, AK Futures. This case was a trademark infringement matter, but what it actually did is it gave rise to the hemp cannabinoid market in the United States, because it said that so long as the party's goods contained, had a cannabis product or a cannabis extract that had less than 0.3% THC, it was federally lawful, so they were entitled to trademark rights. The idea was that if you had some other kind of THC derived from some other part of the plant or a different cannabinoid, is that product legal for the purposes of trademark rights? And the court said, yeah, listen, as long as the Delta-9 THC is less than 0.3%, you're totally fine, trademark rights acknowledged. So there's a lot of new and upcoming stuff in the US, and one is that there's a lot of mainstream companies that are suing the cannabis sector, and this isn't just for the infringement that feels like parody. It's a lot of lawsuits that are arising because mainstream companies want to actually enter the cannabis sector. And we still have a lot of infringement of mainstream marks in, like you can see here, Toys R Us versus Zaza's R Us, where people think that parody is a defense, and we know that it's very limited when it comes to trademark laws in the United States. And we still have a lot of this, and it's really a troubling problem in the US, where cannabis brands infringe on a lot of candy brand names and things like that. And then we have some really interesting partnerships. This is actually a totally legitimate partnership between a big cannabis company in California called Cookies and DC Comics. They have an actual agreement between them for apparel branded by both companies. This is controversial in California because we have a prohibition on anything that's child-friendly, so any branding or trademarks or imagery that may appeal to children is prohibited on cannabis goods that are sold in California. This is true actually of pretty much any state that has legal cannabis, and yet this is allowed to happen right now in California. It's really controversial, and we don't know if there will be enforcement. In some states, actually, certain colors are prohibited, and certain words are prohibited because they're either the names of candies or they are known to be child-friendly. And so we don't allow cannabis companies to use those colors, that imagery, or those terms. Okay? So a little bit more on marketing in cannabis in Canada.
I just have a question from your last slide.
Yeah.
So apart from DC Comics, like the imagery, is Cookies, to just have the trademark for Cookies, isn't that also appealing to young people?
Yeah.
Is there issues with that?
I mean, a lot of people say that there are, and there's often, every few years, somebody gets mad about Cookies being around. And so, yeah, that question comes up. The word candy is actually prohibited as a use for cannabis companies in California, so it's unusual that Cookies is allowed. But yeah, that comes up all the time, and we have that problem. And actually what's interesting is in California, we have rules that require even the apparel that has a cannabis brand on it to include a cannabis license, and a lot of companies don't abide by that. And Cookies has tried over the years to really position itself as an apparel company, not a cannabis company, but it's also a really well-known cannabis company. And so now with some of our rules around apparel that has cannabis branding on it, it's really forcing these two concepts together. So if you were a cannabis company and you were gonna try and develop a real apparel brand to get your name out there. Now you're forced to kind of let the consumer know that this is a cannabis brand and here's my license number under which I'm operating a cannabis brand. So it's really controversial. It's what we refer to as a legacy company. Cookies has been around forever, long before we even had legal cannabis in California, or adult use legal cannabis. And so I think there's some degree of like accepting what's been going on for so long.
All right.
Oh, let me do this.
Okay. Do you want to do this? Okay, so advertising promotional restrictions in Canada, I alluded to this earlier. It does resemble the tobacco industry more than the alcohol industry. There's a blanket prohibition on advertising, subject to limited restrictions, which I'll speak about. Really, the policy goals in Canada, which is taken very seriously, is to protect public health, protect young people and others from inducements to use cannabis. These two definitions become relevant when you are looking at what is allowed on your packaging and what is allowed by way of promotion. A brand element includes a brand name, trademark, trade name, distinguishing guise, logo, graphic arrangement, design, or slogan that is reasonably associated with or that evokes cannabis, a cannabis accessory or service related to cannabis, or a brand of any cannabis, cannabis accessory or service related to cannabis. So in terms of the prohibition, it is prohibited to promote cannabis or a cannabis accessory or any service related to cannabis, including, and just most importantly here, to do so in a manner that there are reasonable grounds to believe could be appealing to young persons, by means of a testimonial or endorsement, however displayed or communicated, by means of the depiction of a person, character, or animal, whether real or fictional, and then the last one, by presenting it or any of its brand elements in a manner that associates it or the brand element with or evokes a positive or negative emotion about or image of a way of life, such as one that includes glamour, recreation, excitement, vitality, risk, or daring. So that's open to interpretation. Some other prohibitions, obviously not false, misleading, or deceptive. You can't promote through foreign media. No sponsorships, or can't be a name of a facility or inducements. So the exceptions, and you'll see it's subject to the regulations, a person that is authorized. So when you say in the act, a person that is authorized, that's anybody that has a license to produce, sell, or distribute cannabis. And that's important because I have had clients that don't have licenses, but that are working for other companies, and they can't promote because they aren't authorized to do any of these things. So the exceptions allow you to promote basically in communications that are addressed or sent to an individual who is 18 years of age or older, or in a place where young people are not permitted by law. Those are the main exceptions. There's also point of sale exceptions and brand element on other thing exceptions. There's a lot of different exceptions. I'm not going to go into them. And again, this is where it does not apply. For example, literary, dramatic, musical work, or a report or opinion, that kind of thing. So this is just an example of something that was not compliant in terms of promotion, because you'll see the words there: unwind, relax, center, and enhance. So that was actually in Nova Scotia. It was one of the retail outlets, and they were found to be non-compliant because of these words that go against the whole vitality and glamour and way of life.
And this is inside the dispensary?
Yeah.
That's actually really interesting because there's a really big trend in the US specifically to identify the cannabis product in accordance with how you might feel upon consuming it. So this would be something that would absolutely be a way that a cannabis company in the US might try and promote its brand. And and using exactly these words, like it might relax you or it might help you unwind. I mean, we have a product that the product name is chill. So it's interesting that even in the dispensary, you wouldn't be able to do that.
Yeah. And here too is another sort of, they look like they're having a good time.
Shame on them.
So this is
Not
not
allowed.
allowed. This is not allowed.
It's literally not allowed. So we have certain restrictions in the states on, some states prohibit advertising that shows the consumption of cannabis. And then some states you can even show that. And what's kind of interesting as a comparison here is there's a lot of influencers that now work for cannabis companies. And when we draft influencer agreements, we always have to be cautious to ensure that they don't show themselves consuming cannabis, A, in a state that's identifiable and is a prohibition state, and B, that they're that maybe they don't consume cannabis at all if they are promoting on a social media channel that is available in all 50 states. Potentially, the cannabis company could get into trouble for that. But otherwise, this would be an ad
And
that
this is
might
also
be,
a depiction of a person too, so you can't have people.
yeah, that's
too.
right. Yeah, exactly. You can't even have people. We had this coming up in California. We had a law that was just before our legislature that sought to prohibit people on cannabis packaging, and there was a big lobbying effort against it because that meant you couldn't even show a farmer on, and that's a
right.
big deal in California, is the California farmer cannabis cultivation history is just really well known, and people really support their farmers. So you couldn't even have that in Canada.
Yeah. Okay, so this is what our packaging and labeling looks like.
We should
So
have done a comparison with some U.S.
yeah, I know.
Next time.
So it must be a single uniform color. You cannot use fluorescent or metallic colors for packaging. Limited items can appear on the package. So going back to what I said was a brand element, you can have one brand element on your packaging. You can have a brand name, and then you have to have certain other things on the packaging, like the health warning, the THC standardized symbol. Must be smooth, no decorative features. Must have child-resistant features. Cannot emit scent or sounds, no cutout windows, no inserts, leaflets attached to packaging. So these are some examples of what it looks like. So when I said earlier, when you walk into a store, it is hard to differentiate between what you're buying. I mean, you do see the brand element there. You know that's Tweed, but then you need to do your own research as a consumer to know what you're really buying.
One question there. Because you have to package the product in one single color, can you have trademark protection over that single color? Despite of...
I think you can. I think that you can get color trademarks. I don't know if anybody's tried that, to do that, but yeah, it's interesting. No.
The question was whether the colors are unique to different companies, and no. So that blue packaging of Tweed, so is there maybe another company could have that same shade blue packaging?
They technically could,
Yeah.
unless someone
Yeah,
tries to
had
protect
thought,
the color.
Boy, you
Yeah.
really can't tell the difference between these products.
Yeah. All right, so this is some more detail on this. I'm not going to go through each of the regulations, but there is, and I don't have it here, but you see the warning symbol and the THC symbol. There are even restrictions to how big your brand name can be and your brand element. So the text, for example, in your brand name can't be bigger than the text in the warning label. And then your logo, if you were to have a logo, that can't be bigger than the THC symbol. So I don't know, I'm not a regulatory lawyer. I mean, I do, as a trademark lawyer, have to look at this a lot. But I do rely on my regulatory lawyers a lot because there's a lot of detail with what you can do with your packaging and labeling. So just to talk a little bit about trademarks in Canada, they are allowed, thankfully. And in Canada, there's no use requirement, which is great too, because you could protect your brand in your cannabis product or service for what you are planning to do into the future. The only time, use comes up is when there's a third-party cancellation after 3 years of having your registration. You can get trademark for traditional and non-traditional marks like scent and taste. SIPO does not examine for whether you're compliant with the Health Canada regulations. So that's where it becomes interesting. As a trademark lawyer, that's where you need to be advising your clients when they come and they ask you to have a trademark for a logo or a word. You need to be able to tell them you can do whatever you want within the normal trademark laws, but you need to be able to eventually use the trademark that you're filing for. So when you're coming up with filing strategies for your client, you got to look at the regulatory and trademark laws, because SIPO's not going to, unlike in the US, SIPO's not going to do that. In terms of you can file for cannabis goods, but then if you're going outside of cannabis and trying to get trademark registrations elsewhere, you need to keep in mind that there's some jurisdictions, and we'll go into this later, that you can't have cannabis as part of your specification. Like, I'm not going to say US because you can't get a federal trademark, but let's say in other countries where you can get a trademark, but you can't, there's some jurisdictions where you can't mention cannabis, so you have to take that into account when you're advising on filing strategies. So that's basically what I say here. You have to choose a brand element that can actually be used in your promotional activities and your packaging and labeling. And I think that's all really.
So you wouldn't say cannabis in the application?
So you do for Canada, but I'm just saying, like, and like I said before, there's a whole list of goods and services on our pre-approved list that has that. But there's some countries, like you may want to file another one where if you want to rely on priority, you wouldn't mention cannabis so that you can apply in other jurisdictions. For example, I think in Europe, for example, there's some countries where you can't, and I can't think of which country it is off the top of my head, but you can't put cannabis into the specification because it will instantly be denied. Yeah. And then trying to think if there's any other sort of good tidbits here. I think that's it. You can't, your trademark can't be held to be invalid based on compliance with the Cannabis Act. So that's your job and Health Canada's job to crack down on that, but that doesn't come into consideration from a trademarks examiner at SIPO.
Can that be a basis for seeking invalidity of a trademark registration?
It could be, and I could see it as a basis, a ground of opposition. Mm-hmm. Let's say, I always thought about this at the beginning when I did actually see a lot of applications for strain names, and I was getting, I was watching them closely because in the US you can't get it, and in Canada they weren't examining for that, but they did start to, after some time they did start to realize that. But I was trying to find clients that would help oppose those applications based on the strain name, because that's not a proper, doesn't function as a trademark, a strain name. So it could be, it just hasn't happened yet. Just hasn't happened. And that's because it's so slow to get a trademark still. We're still looking at trademarks that were filed in 2019. So the ones that were filed in 2017 and 2018 when this became legalized, not many of them are still not registered. So, but yeah. And there is I was thinking Toys R Us is
Toys R Us.
Toys R Us.
Ripping off Toys R Us.
But there has been a few cases between cannabis companies and non-cannabis companies where sometimes there's trademark infringement found, but we have something called depreciation of goodwill in Canada where there's a lot of companies that, because of the stigma associated with cannabis amongst consumers, depreciation of goodwill does work sometimes if you are acting for a major company that doesn't want to be associated with a cannabis company. So Toys R Us and Herbs R Us is an example of one of them, and then Subway and Budway, which you'll see like it was also passing off that was found in trademark infringement here. And Skittles was another case.
There was actually a really interesting case of infringement of that Skittles mark in the United States as well, with a strain name called Skittles, which is very similar to Skittles. And the court had a really hard time kind of teasing out the idea of whether this was even trademark use, and the parties ended up settling outside of court, and the cannabis company is still using Skittles as a varietal name. It's interesting challenges when it's difficult for the courts to understand the use of the mark in the cannabis sector. Like, what is that word doing? Is it a varietal name? Is it a trademark? So we've had some.
Skittles has also had a bad.
Yeah, poor Skittles.
Skittles and Toys R Us. Okay, now there's
Back to Gloria.
Mexico. Yes.
Okay, so funny because we don't have full legalization of cannabis, but the Mexican Trademark Office, INPI, has been allowing a lot of registrations for trademarks applying or covering cannabis and derivatives. So we're gonna go through examples here. And Shabnam, I remember you said that there was not a real obstacle when it comes to the name of the brand. You don't have immoral prohibitions or something alike. But when it comes to the actual coverage of the trademark, the goods or services, you can have an unlawful impediment, right? So in Mexico, we have been seeing a lot that the Trademark Office is allowing trademarks for cannabis products in a lot of classes. For pharmaceuticals in class 5, for cosmetics in 3, and in 32 for beers and other beverages, and 34, of course, for cannabis and tobacco. And funny, I mean, it's really interesting because we do have a prohibition against the public order. You won't be allowing a trademark that goes against the public order. We used to have one about uses and good customs, which was banned, was eliminated from the law. But still, we have seen this 360 full change when it comes to the practices of INPI. So you might not face legal obstacles to obtain registration, but what happens about the use of it? In Mexico, you don't need to prove use in order to obtain a registration. You will have to file a declaration of use after the 3rd anniversary of the granting of the registration. So you can have a registration valid for 3 years, but then any third with interest can actually file a non-use cancellation action, and same, you have to file a declaration of use on bona fide basis. So what would happen then? Can we invoke an exception to this non-use because we don't have the full and complete legal system prepared for an individual or an entity to commercialize cannabis products? So this is one of the questions here right now in the IP, for the IP practitioners in Mexico. So despite of this absence of approved federal law for recreational cannabis use, INPI, as I mentioned, has been granting registrations. Also, and I think Shabnam and Natalie, I think we mentioned this in a different conference, that Mexico is aligned with one of the provisions of the Paris Convention, in the sense that the trademark will be valid irrespective of the product's nature, which includes the unlawful status of those goods. So these are 3 examples that have been matured into registration. Thank you. TO1 Cannabis with this very creative and artistic woman with cannabis hair, and purple other hair, Fire Flower Cannabis and Cannabis Clan. They cover class 21 for grinders and 34 for dried marijuana and other related cannabis goods. These are other two examples for El Cannabiquero, which is, I would say, the man of the cannabis. Maybe that's an attempt of describing a person that is involved in the cannabis industry. And Cannabis, which was granted in 2022, and the other in 2023. So these are very recent examples, both for 34.
You know, you could actually bring, if you tried to bring that application with those goods, smoking herbs, oral vaporizers for smokers, which doesn't say anything at all about cannabis, if you had that application in the United States, the examining attorney would search for the mark and the brand and the company, and if they identified that it was a cannabis company, then they would ask you, is this, you know, for use with cannabis? And you would have to answer that question and either be denied registration, or you could try and say that it was just hemp lower than 0.3% THC. But the issue is that there's so many applications filed at the USPTO for cannabis companies that they won't even, it's not sufficient anymore to be really broad. They will investigate the use. I once had an examining attorney send to me a video that my client had on YouTube of smoking its own vaporizer, of inhaling its vaporizer, and then they told me that the goods and services were illegal as evidenced by the video on the internet.
That's an example, though, of where, so you wouldn't get away with that in the US, but if you tried to file for that in Canada and wanted to get into other markets, you would use class 34 to try and get a registration where you may not otherwise get a registration and have a broad specification like that.
So would you have two different applications?
You could. I mean, it's all the filing strategies, right? In terms of like what your client would want at the end of the day in terms of coverage globally, because that's always the struggle, is the global presence. Right. So.
This is an example of how the Trademark Office in Mexico objected back in 2018. Sorry, yes, thank you. How the Mexican Trademark Office objected this trademark, Goodfield's Cannabis Co. The objection was based on the fact that cannabis back in the day was prohibited for its cultivation, preparation, acquisition, commercialization, use, and consumption. So it was contrary to public order. Remember that I said that we have a provision prohibiting trademarks or any other registration of IP that goes against public order and good customs. Now we don't have good customs in it, but still it incited to its consumption, etc. So it was denied. So the applicant filed an objection, and in 2021, the Trademark Office granted a registration. So this is a good example of how the Trademark Office, what they did was, I'm gonna issue an office action. You will have the chance to argue against it. And because of the timing of this very uncertain scenario for the regulation of cannabis from a legal perspective, INPI, instead of formally denying the mark at the end or issuing a formal objection, because there's a provisional objection and then they can deny without doubt the registration, they paused the examination. That's why it took almost 3 years for INPI to grant the registration. Not because they don't have a workload very significant, I mean, they do have a lot of work, but they are very speedy with the processes in Mexico, different to the Canadian system right now. But they did that because they wanted to understand if any change would be coming into existence, and they did, and so that's a successful case of how INPI has been waiting for regulations or judicial precedents. Other impediments for the canna worth, it's cannabis in class 34, which was contrary to morals and good customs because this was a 2015 application. And also there was, this is interesting, there was this obvious objection about descriptiveness because it was cannabis. Actually, and I think I saw the logo for this mark in your slides, Natalie. This is the cross, the green cross with cannabis on it. So despite of having a logo, it was deemed descriptive and it didn't become a registration. Lab, which doesn't have cannabis, but it does evoke to cannabis, was refused on descriptiveness grounds in 2020, and it was challenged, and it is still pending. So my guess is that, well, I don't know, this is really not related to the cannabis objections, but it is an interesting case of how you will understand if it is indicative or it is just suggestive or evoking to cannabis. And finally, Cannabis, it was abandoned 2021. It was deemed also a variation in the spelling of a descriptive term. Other examples, as mentioned before, we don't have, the INPI doesn't have the power to register a mark that is contrary to public order. But despite of that, because we don't have the contrary to good customs and practices prohibition right now, they have been allowing registrations for trademarks such as these that are listed. Condensant cruise, normally a few years ago, these might not be allowed, or at least it would be objected initially, and they have been going through registration without any kind of impediment. So to summarize the criteria of INPI, the trademark office, they have been allowing the registrations of all trademarks that comprise cannabis slang or the word cannabis on it, and expressly encompassing cannabis or marijuana within the goods services specifications, as opposed to the US system. The office, they don't dig too much into the actual commercial application of the brand. And as long as they do not incur in absolute grounds, which is a great example, descriptiveness and or relative grounds when there is a similar mark, they will proceed to registration. So one of the recommendations to our clients is to go ahead and try to anticipate those portfolios in Mexico and other countries. Finally, regarding the trademarks, thank you. As I already raised that you have to file as a registrant a declaration of use after the third anniversary of your mark. So what will happen if by then you don't have the full authorization, the full permit from the regulatory authority to do what you want to do with your product? So you want to have proof of use to support your registration. So a lot of debate is going on when it comes to these kinds of declaration of use, and we're going to see what happens. We don't have a criteria right now for that. And because we're in Mexico and appellations of origin are very important in Mexico, we can also speculate about what's going to happen with the appellations of origin related to cannabis in Mexico. Our guess is that they will likely not be allowed at this time because we don't have full regulation and legalization of cannabis. But when they do, this is going to be a very important topic to discuss. And finally, I am really eager to know what's going on about the patent side, Eric, in the US. In Mexico, we have a lot of pending patent applications related to cultivation, medicines, greenhouse equipment, extraction methods, but we don't have any patent granted because of this very uncertain scenario. So despite we are among the Latin American with the most patent applications, we really have no clue about what's going to happen. So eager to hear about what you're going to be talking about a little bit later. And sorry, I have another more. I didn't know. Copyright. Here, the trend in Mexico is to obtain as much IP protection as possible as a favorable scenario for the cannabis industry. So we have seen, those are two examples of how you can seek protection of the title of a magazine publication. One example is Cáñamo and the other is Porro, and we haven't been receiving objections from the Copyright Office, so that's another strategy from an IP perspective. Other aspects, which is also in the air right now, it's what's going to happen about the licensing and transferring industrial property rights, advertising, and plant varieties. So regarding plant varieties, we have been accepting the SNCs, which is the authority certifying some seeds and varieties, plant varieties that depend on specific cannabis seeds. They have allowed two seeds in Mexico, which is really groundbreaking, I would say, but still we don't have patents related to all this infrastructure needed in order to develop the seeds, so we are also in abeyance here. And finally, yes, this is the last slide, aspects to consider in the future. We don't have any specific regulation regarding the advertisement of these goods because, as mentioned, we don't have a full display of provisions for it. But we can only think about other heavily regulated industries where registrations have been heavily imposed on the labeling and the packaging, such as tobacco, high sugar content, friendly for child also, junk food, alcoholic beverages, and we think that the government is going to be very strict about the advertising. Hopefully not so strict as in Canada, but let's see what happens next. And I think this is it for me.
Thank you so much, Gloria. What do you think about we skip some of these slides and we'll get to the patent section, and then we have our case study, so we'll have maybe 10 minutes to go through the example fact pattern and talk about the strategies for our example fact pattern cannabis company in all of these areas, and we'll take some questions and input. Okay, status of patent law.
Hi everyone, my name is Eric Moran. I am a practicing patent attorney for the past 22 years, all with the firm McDonnell, Boehnen, Hulbert, and Berghoff in Chicago. Very happy to be here today. So let's first talk about what is a patent. A patent is the exclusive right to prevent others from making, using, selling, offering for sale, or importing into the United States a claimed invention for a limited period of time. Now, patent is a quid pro quo, right? In exchange for that exclusive right, patent owners need to fully disclose their patent in a patent application such that one of skill in the art can make or use that invention. So it's offering the benefit to the public of the technological advance that is the invention in exchange for the right to stop other people from practicing that invention for a limited time, usually 20 years from the date of filing of a utility patent. In the US, patents are actually a constitutional right. They're in our Constitution, enshrined in Article 1, Section 8, Clause 8, just like copyrights, unlike trademarks. And the good news is, for everyone here, patents are available to cannabis companies. There are no requirements on use, legality, or safety. Other agencies all take care of that. The USPTO doesn't care at all about the fact that inventions are directed to cannabis and that cannabis may be federally illegal or argue, some people may consider it dangerous. That doesn't matter at the patent office, unlike the trademark office. So why do we patent? A patent gives the patent owner the right to exclude other people from practicing the invention. Now, it's not a right for the owner of the patent to actually practice, right? It's not a right to practice, it's the right to exclude. But there could be a competitive advantage if you are able to stop your competitors from practicing certain technologies or certain inventions. A lot of companies use patents to generate licensing programs. They'll go out and enforce their patents, extract royalty-bearing licenses from infringers. Some companies patent a little bit more defensively and try to cover technology so that their competitors can't cover that technology. And just in general, patent portfolios can be a really large, big source of valuation for companies. So in the US, we have 3 types of patents available, all of which are available to cannabis companies: utility patents, design patents, and plant patents. The one that we are probably most familiar with are utility patents. Utility patents protect the new or useful process, machine, manufacture, or composition of material. So they are the types of patents that cover technology, right? They cover the structure, the function, the composition of something. They cannot cover abstract ideas, natural phenomena, or products of nature. So patents could not cover, for example, an existing strain of cannabis that is found naturally in nature. Patents are infringed when others make, use, sell, offer to sell, or import the invention into the United States. Now, the interesting thing about utility patents is that they offer the broadest protection to an owner of a patent owner, much more broad than design patents and much broader than plant patents. But they are by far the most expensive patent to obtain, several, tens of thousands of dollars in many cases in the United States. And they're very time consuming. They take 3 to 5 years sometimes in order to get a patent to be granted from the USPTO, a utility patent to be granted from the USPTO after filing. In the cannabis space, by far, utility patents are the most prevalent. And we did a count a few months ago. There are at least 1,000 granted patents directed to cannabis products. And we found 2,000 published applications also involving cannabis-related products. So a lot of applications are getting filed at the USPTO directed to cannabis products. So I think it'd be helpful if we went through parts of a utility patent. Would you mind clicking on the first document we have there? So just so everybody sees exactly what a utility patent looks like, we're going to try to call it up on the screen here.
While we wait for that, I'll say my company has a design patent covering the shape of our pill. Right?
Yes, yes. Okay, so here's the front page of a utility patent. You can see we have the title of the invention, the inventors, the patent number, the date of issue, which is the date that the patent from which the patent can be enforced. There are filing dates. This is sort of a complicated filing history, but there's an early filing date out of Germany, maybe that says. And that's the date of priority, so that determines who has the first to file in most jurisdictions, and including the United States, has priority, so that helps determine priority of the patent. On the right-hand side, there's a list of references in the right-hand column. In the United States, there's a duty of candor, so if an applicant or its attorneys know of relevant prior art, so relevant inventions that may have come before, relevant patents that may have come before, they must disclose those to the USPTO during prosecution. There's an abstract that provides a general summary of what that application or patent covers. Utility patents usually contain many, many different drawings. This particular utility patent is directed to a method of extracting THC from the flower, from cannabis, and it involves, this is a flow diagram of a process that would be used in a processing plant, a manufacturing facility, to extract that THC. And so there are a lot of drawings like this demonstrating what the invention actually is. And then the patent includes a very detailed description of the invention. And this is required. We talked about patents being a quid pro quo. This is what the inventor gives up when trying to obtain the exclusive right to the patent. So the specification, once it's written, cannot be changed at all, right? This is now written in stone in this patent. At the end of the specification, we have what we call claims. There are these numbered paragraphs you can see in the right-hand column, column 14. The claims can be changed after filing, and they can be changed. Usually they get changed through a negotiation process with the USPTO. When the examining attorney finds prior art, the applicant and the applicant's attorneys negotiate with the examiner to determine the proper scope of any invention that might issue from the patent. So the claims are the most important part. They define the scope of the invention, the metes and bounds of the invention, and they're found at the very end of a utility patent.
How is it possible that there wasn't prior art for the extraction of THC from a cannabis plant, considering people have been doing this for 30 years?
Yeah, That particular patent, I believe, was directed to a special aspect of the process. I don't know if it was using heat or certain chemicals, but it had to be something that was new and non-obvious, right? So it couldn't have been just an obvious variation of the prior processes. It had to be something that actually made a technological advance. So the next type of patent we want to talk about are design patents. Design patents, they're used by cannabis companies, like Shabnam's company. And design patents protect new, original, and ornamental designs. They can cover the shape, color, decorations, or features of those designs, but they cannot protect anything that's functional. And that's a big gray area, and that's the subject of all kinds of litigation in the design patent world. Design patents are generally infringed by the direct copying of the design, so they're really directed to preventing sort of knockoff designs. They're very quick to obtain. Design patents can issue within a year of filing, which is very quick at the USPTO. They're very inexpensive compared to, let's say, a utility patent or a plant patent. Design patents are valid from 15 years from the date of grant. And now we're going to take a quick look at a design patent that we're going to call up onto the screen. And this is actually the patent that our firm obtained for 1906 for Shabnam's company. And you can see in this patent, it looks very similar. The front page looks very similar to a utility patent, but design patents don't have any sort of specification, right? The design patents include one claim, and the claim is actually the drawing or the set of drawings that comprise the actual design. And so this design patent is directed to the oral tablet that 1906 sells for its various product lines. So this is the front page of the patent. Again, there are some references that are cited and some fields that the USPTO uses, but then the design patent includes drawings of the design from every different angle, right? Usually there are 5 or 6 or 7 of these drawings. Here we have 7, and then design patents can include various embodiments too. And so we have one embodiment with 1906, another embodiment without 1906. So there's a bit of a variety of a scope of protection. Okay, the third type of patent that we want to talk about are plant patents. Plant patents protect new varieties of plants that can be reproduced asexually. So they can protect cannabis strains in the United States. The plants can't be naturally occurring. And we'll take a quick look at a plant patent. Oh, could you find number 3? 3? Oh, okay. 3, please. Okay, so here we have an example of a plant patent. The plant patent looks very similar to a utility patent. It includes a written description that is a thorough description of the botany of the plant. In this case, it's quite a long description. And the only claim then in a plant patent is an actual photograph of the plant itself. And so plant patents will include photographs of the plant varietal. Okay, can you put up number 4 now, please? So just lastly, I just wanted to flip through a few examples of how cannabis companies are using patents in the United States. So we're going to first go through a few examples of utility patents. Here's a utility patent directed to a method of treating a sleep disorder, so a therapeutic. The claim recites, so this is what the invention is, recites a ratio of CBD to THC to CBN, excuse me. And I included one figure from the patent to show that the patentee included test results. So they tested various ratios of these ingredients, and they published the test results, which could be used during the patent examination process to show that the patent is actually non-obvious. So it's important, when possible, to include test results and such data, research data, when preparing utility patents. Here's a utility patent directed to a consumable for treating a disease. a utility patent directed to a powder formulation for adding to a pharmaceutical product. Here's a utility patent directed to an inhalation device for cannabis administering. So this is a patent, we just looked at this one. This is a method of extracting THC from flower. This is a utility patent directed to a vape pen. And here's a utility patent directed to a K-cup, so a method of brewing cannabis-infused beverages. As far as design patents are concerned, here's a design patent directed to a consumable tablet that we looked at before. Here's a design patent directed to a method of packaging cannabis, presumably cannabis joints. And here's another method of packaging cannabis, again, pre-rolled joints. And then here we have a few plant patents. Here's a plant patent directed to Ecuadorian sativa, a plant patent directed to lemon crush OG, a plant patent directed to grape lollipop, and here's one directed to Holy Crunch. So that's kind of what I wanted to cover today. If you want to go into our
Great,
case
thank
study.
you.
Thank
Yeah,
you very much.
let's, if we can switch back over to the PowerPoint, please. I feel like all of those patents are being infringed right now because I know, I mean, especially the THC, CBN, CBD, that's a really popular combination of cannabinoids now in sleep products. And I can think of several companies that have a product on the market for sleep, which of course you can't make a medical claim, so you couldn't say it cures insomnia, but they kind of advertise it as sleep products and they have CBN in them. So let's do a quick case study with the few minutes that we have left. It'll come up in a second. Our case study is gonna be, perfect, thank you, is, no? Okay. I have to wait a minute. It's company, oh, here we go. Okay, so we have, whoops, look at it, I went too far. Are you guys doing it or am I doing it? Oh, you're doing it, okay. So we have an example here of a vape pen, and we've sort of broken out how the different pieces of it that you might be able to protect. And I'm gonna kind of just go through these slides and get to the fact pattern. Perfect, so there's obviously design and utility patents here that you can secure that Eric just talked about. Design patent for the ornamental design of the top of the vape pen, utility patents covering the vape pen battery. Am I controlling now? Yes, I am. No? Okay, so our case study is that company that had the vape pen lit is a US company based in California, and they've been making cannabis extracts using CO2 extraction methods since 2015. Unlike other CO2 extractions, lit uses a secret ingredient during the extraction process that turns the cannabis oil into a metallic gold color. Lit also has a flower brand called Lowell. There actually is a flower brand in California called Lowell. They're a licensed operator in California and have a cultivation site and license, a manufacturing license, and a micro license that allows them to sell directly to consumers in California. They're really good at developing varietals and want to name their varietals and get those names registered as trademarks. Lit also manufactures a cannabis-infused lollipop that it calls the Lit Pop. The Lit Pop can cure COVID if it's eaten at the very onset of symptoms. Recently, Lit has decided it wants to expand its presence into several other states, namely New York, Oregon, and Nevada. What is the best strategy for Lit to protect its IP and to expand into other states and countries? Well, I want to walk through our example. What is the next slide? Does anybody? Can I see them? Oh, I am. Okay, great. So from the U.S. perspective, and if anyone has questions or ideas, they can jump in. The trademark Lit is potentially protectable at the U.S. Patent and Trademark Office. I think that it would probably get a descriptiveness refusal in part if you were to even say like it was lit for a hemp extract or something of that nature. But on those earlier slides showing the product Lit, you could actually get a trademark registration for the battery part of the vape pen, so maybe Lit for use in connection with a battery that operates an e-cigarette, or Lit for use in connection with an empty cartridge that's used with some sort of oil, or you could maybe say a cannabis oil with less than 0.3% THC. Packaging is very hard to protect as trade dress in the U.S. because you have to indicate what the packaging contains, and in this case, you wouldn't be able to say that it contains cannabis oil, but maybe you could get a design patent over the packaging, sure. And the varietal names for lit are not protectable as descriptive under US law, but there could be options to secure plant patents for some of their different varietals they're coming up with. You could actually seek registration for the trademarks at the state level in the US. Some states undergo real examination the way the USPTO does, the state of California does that, and you will be refused registration based on descriptiveness, if it's a varietal name, and actually for lack of compliance with the state regulations on packaging. So unlike Canada, not only does the US Patent and Trademark Office meddle into what you're doing, but the state trademark offices do as well. So the best option for expansion into other states is probably using IP licensing agreements. That's what a lot of companies in the US do. That's what 1906 does. And that's where you license your, whether it's a patent or maybe you have a trade secret, definitely your brand, to a company that holds a permit to operate in a different state, and they handle the manufacturing and distribution and sales, and then would package the goods in packaging that is compliant with that state's laws. You can set up different kinds of royalty schemes. In some states, you would have to register as a brand license holder, like in the state of New York. You need to obtain that kind of registration even if you're not the company that's manufacturing the goods. Medical claims are not allowed, so lit would not be able to say in any state that their product cures COVID. There's a lot of companies that kind of get close to that line. In the US, we do permit structure function claims, so it's this sort of kind of getting close at what the product can do or impact it can have on the structure or function of the body for humans. So that's kind of the US perspective of how this company might expand. You also could actually get a license to operate in various states. We call those multi-state operators in the US, and they're sort of taking over the market the way big companies are in Canada, MSOs. But that's a really high cost to entry in different markets because you often have to have a presence in the market, you have to have a physical site in that market, and you might have to get multiple licenses to do the thing that you want to do. And it's very cost prohibitive for companies, so the IP licensing tends to be the way that companies can sort of quickly enter various markets. Okay, next. Expansion into Canada and Europe. So last week, an investor based in the UK approached lit and wants to make an investment. This investor also invests in a large Canadian company, and the investor would like to bring lit and all of lit's products into Canada. What should lit do to protect itself as it explores this opportunity?
I have some thoughts. Similar to in the US, if for lit itself, in terms of protecting that trademark, I think that would also get a clearly descriptive or not inherently distinctive citation. In Canada, although you can file it, like a filing strategy is to file it and keep it pending for a very long time, as you would in Canada, because it takes forever for trademarks to be examined, and then acquire distinctiveness and then file again based on distinctiveness evidence if you have sales and reputation in Canada. In terms of what are some of the other things? Let me just see.
The product type, could they export that lollipop product, the Lit Pop, into Canada?
I don't know about export into
Export the IP.
the IP lit pop would have the same issue, and then with respect to, I don't know if you see on this slide, these are all in terms of the vape pen, like the product and the accessory, these are all cannabis or cannabis products. If the vape pen was sold without extract, it would be a cannabis product. If it would be a cannabis accessory, and if it was with extract, it would be a cannabis product. So they would all be subject to the regulations that I discussed earlier. So your packaging would be likely different than what you would have in the US. It would be very strict in terms of being a single color. Lit would probably only be able to appear once. And you'd have all the other regulatory restrictions that I discussed. I just wanted to show this this example of what is actually compliant in Canada. So at the bottom, That's, again, Tweed is Canopy Growth is a very big company in Canada, and they have a brand called Tweed. And on the right there is what their vape pen would look like. So that would be similar to what would be the case in this situation. And then the packaging, again, you'll see here, that's what the packaging of the vape pen will look like. Interestingly, when I was researching this and I went onto the website and I saw their packaging doesn't look anything on their website like what's actually sold, which I thought was something I didn't really consider before. But when you're looking at, they can promote their products if it's in communications, like they have the age gating on websites, but they made their packaging on their website look a little bit more interesting, but that's not actually what you can buy in the stores. So I don't know if this was strategic for them to make it look better and entice more people to buy it, but for advertising, I don't know the answer to this, and I actually asked my regulatory lawyers right before I came. I'm like, why is it like this? And they said, oh, that's interesting. I don't know. But I think that it is probably compliant because it's the packaging and the labeling restrictions. Go ahead.
Would it be possible to make an inside package, like for an experience package? Would it be possible to make like an inside package, like for an experience package? So you go to the store, you get this, but when you open, you get the other package?
No. All the packages, all the different containers in the packages have to be compliant. Okay. Yeah. Good question, though. Yeah. So that's sort of my 2 cents on what you could do with this product in Canada. And obviously with the different brands and products that were in the original case study, we would do the clearance searches and see what we can get registered in Canada federally.
And you wouldn't export the product directly from the United States to Canada because that would violate everybody's laws, but you would enter into an IP licensing agreement, so maybe Lit would have an agreement with who's Canopy to have that product in Canada. And actually we know some that cannabis beverage has this kind of relationship with a licensed processor in Canada and therefore is essentially a multinational company. We're out of time. Do we have any questions? Yes. Oh, she's bringing you a microphone.
Thank you very Hi, my name is Shadia Ponce. Thank you very much for this great exposition. It was very clear and very interesting. And I just have one question very quickly. When Mexico was starting to think about regulating cannabis and the use of CBD, I remember that AMPI, Mexican Association of Intellectual Property Protection, gave a specific forum where they were talking about the situation in Canada, the US, and in Mexico as well. And I have this idea that Canada was one of the most important examples from where Mexico was trying to take the regulation from Canada as well as from Colombia. But I remember very well that from Canada, they were saying that you as a country were trying to be like a referent, no, that has to be with the taking care of diseases, mental diseases, regarding or related with CBD medical use. So I just wanted to ask you if this is the current situation as well. Canada is still trying to be like the most important country that is seeking to protect CBD and separating it from THC, because this was one of the most important problems that you had in Canada, the difference between CBD and THC. So we were talking about Parkinson, arthritis, multiple sclerosis, and many other diseases. But the problem, well, maybe it is not an IP question, I know, but as corporate lawyers, we need to know how the industry is moving forward, because I used to see, for example, cosmetic purposes as well for the use of CBD, or medical purposes. So I just want to know that about Canada, and for the US, if it is correct to know, to understand or to say that what you're seeking, or your most important goal right now, is to regulate the use, but as a recreational use. Thank you very much.
So, so if I'm understanding your question with respect to the medical use to cure certain diseases, that is very important in Canada still. To treat, sorry, not to cure, to treat various different types of, whether it be mental illness or Parkinson's disease. That is actually a lot of companies. There is a lot of that in Canada, and there is importance placed on that for sure. And with respect to our trademarks, we have to specify, for example, it's cannabis to treat, and we have to specify which disease it is, or we can't just say for medical uses. It has to be what specifically it is. So there is importance placed in that, and but the regulations for between medical use and adult use are similar for both for adult use and medical use in terms of what you can do with your cannabis. Does that answer your question? Okay.
Great. Thank you so much. If we have no further questions, I think our workshop is over. Thanks. Was there another question?
Goal that you have in the U.S. to regulate the medical purposes or recreative purposes. I think that was like the most important goal, but I don't know if it is.
You know, it's funny you say that, because I had a question too that I was going to ask the other panelists about what drives the policy in the country. And in the U.S., you know, fear drives the policy, which is that it's still illegal. But at the state level, it really depends on what the marketing of the political movement was. So in many states, it's actually, because they're moving towards adult use regimes, it's about taxing and regulating cannabis, and not really even so much of a focus on medical cannabis. In the state of Washington, they almost have taken away their medical cannabis regime, and the adult use has eaten it up. But there's still a big drive for medical cannabis in a lot of states. Most states like California and Colorado have both medical cannabis and adult use, and they sometimes will have different regulations. And you could, in theory, apply to get like a pharmaceutical drug at the FDA, but it has to be like some sort of synthetic until we get legalization. But at the state level, you can't have a state level pharmaceutical in the US. So any of the medical cannabis is just like kind of anecdotal, I would say, but I don't want to say that because it really does have medical effects, but it's not approved as a drug in any state. We don't have that system. The only drug approval system is at the FDA. But there is really a focus on cannabis as medicine in the states that have robust medical use regulatory markets. So, and you'll often see like a tension between those. In that example of Connecticut, actually, that prohibits pills in the adult use, you can have pills in the medical system there. A lot of states have a limit on how much THC the adult use products can have, but the limits either are not there or are much higher for the medical use. And then, like I said at the very beginning, the medical markets, almost all of them are for 18 and over, whereas adult use is 21 and over. But really, it just depends on like the states, like the public policy in that state toward legalization. And the adult use public policy mentality is often about regulating and taxing and coming up with money for the states. And then the medical use will be really medical focused. And I mean, that's the basis of California's cannabis program, has always sort of been founded in the idea of medicine to help the side effects for HIV patients, which is really where our legal system arose out of. Does that answer? Okay, great. Thank you.
Los esperamos a las 19:30 horas en el lobby del Hotel Presidente Intercontinental para salir a disfrutar de una noche llena de diversión y emoción en la arena de lucha libre mexicana más antigua del país.